Hi, welcome. My name's Phil Winder and I'm the CEO of Winder.ai. As an AI consultancy, we are very interested in what's coming around the corner in terms of regulation. Technical industries have typically flown under the radar when it comes to legislation, but since technology plays such an important part of people's lives today, it's getting harder to suggest that industry is capable of regulating itself. Governments around the world are now considering enacting legislation that places basic requirements on vendors. Well, this presentation introduces the EU AI Act. Okay. I've split it into 8 sections, which represent what I believe are the most important questions about the Act. I've tried to summarize all of the content as much as possible to reduce the length of this talk and also try and condense the information. At the end of this presentation, I'd be happy to answer any of your questions live. You can ask a question by using the chat or comment functionality of your platform. And of course, you can reach out to us at phil@winder.ai or just visit the winder.ai website. Okay, let's get started. So first, let me set the context. I'm investigating this legislation from the perspective of an engineer. I'm interested in the practical steps that I need to take to fulfill my obligations as a vendor. I'm going to take the position of a company that operates in a space that is not controversial. I think this represents most people here, but for anybody that is working in, for example, the defense industry or specifically works with children, be aware that my interpretation may not be correct for your business. I also want to be clear that I consider a lot of the implementation details to fall under the banner of what I call technical AI governance. These are procedures that these are procedures and systems to ensure that AI products do what they're meant to do. This is not the same as corporate governance. Typically in technical AI governance, we implement systems that automate the process of ensuring our things work. It's not the same as the board setting corporate governance strategy. And finally, this should be fairly obvious, but I'm not a lawyer by any stretch of the imagination, so this is not legal advice. Please take everything I say with a pinch of salt. This is just my interpretation. If you need to make business decisions based off the back of this, then I recommend that you either take legal advice or you definitely read it yourself. Okay, so let's go. What's the status? So let's start about talking the current status of the Act. In 2023, the 3 branches of the EU legislature got together to debate the final text, the final wording of the Act. We're now waiting for the publication of that final Act. I was hoping it was going to be here by today, but I still haven't seen it yet. And that text will subsequently be voted into law in the EU Parliament. So let's be clear, it's not finalized. It's not finished. The media has spent a lot of communication. I'm just going to mute my Slack, sorry. The media has spent a lot of time talking about how an agreement has been reached and how it's going to come into law. But actually, it's not been agreed yet. It's not in effect, and we're yet to actually see that final legislative text. So this presentation is based upon the version that was produced in June 2003. So it's a little bit old, but that was the last full version that we got. The EU have said that they expect this to come into law sometime in early 2024, and it should apply to businesses by about 2026. Again, this depends on the specific wording within the text, but it sounds like you've still got a couple of years to get our heads around what the legislation is and what we need to do. Another thing that the media were keen to stress was that they were trying to advertise the fact that this is the first AI law that was being produced by any country in the world. But actually, that's not true either. So China has had a similar AI law, which came into effect on the 13th of July 23. So that's already in effect there. The scope isn't quite as broad as the EU's version, but that was probably the first AI law. All right, let's start with some definitions. So the AI Act has a big list of definitions. Some of them are more technical terms, and some of them I think it's important to highlight now because they will impact what I'm talking about later. So on the left-hand side, we've got the definition of an AI system. This is interesting because it's one of the vaguest definitions in the whole text. The actual wording says something like data inputs leading to system-generated outputs with machine learning and or logic and knowledge-based approaches in the middle. Even the text is like grammatically, it's hard to parse. I'm not even sure it's technically correct, grammatically correct. But I mean, the general theme of what they're trying to get across here is that any algorithm or system that is based upon data, that has been trained upon data, and is generating automated system generated automated outputs, that is what they mean by AI in this case. They also talk about general purpose AI systems. And their definition of that is generally applicable functions. But here, I think what they're trying to say is they're talking about foundation models. They're talking about the types of AI models that you would use to then build off to build subsequent products. So anything that is a foundation model, anything that is generally applicable will fall under this remit of being a general purpose AI system. They talk about safety a little bit, and the premise there is it is a safety component if the malfunctioning of the AI system would endanger the health of safety of persons or property. So equally, if it could damage property in terms of monetary value, or if it could damage real people, then it is part and parcel of a safety component, and more laws will apply to it. More legislation will apply. There's a few others as well that are interesting, like performance, achieve its intended purpose. But anyway, the rest of the definitions are fairly straightforward and what you would expect, so I'm not going to dwell on it here. Another point of interest in the definition section is the definition of a provider. So you are, this is a definition that clarifies who the rules apply to. You are a provider if your name is on the product. Actually, there's a bit of a list here, so I'll try and insert commas if I can. You are a provider if your name is on the product, or you have substantially modified somebody else's product, or you have substantially modified the intended purpose of somebody else's product, or if your service becomes part of a general purpose AI system. So basically, if you build it, doesn't matter if it's yours or if it's somebody else's, if you then ship it and users use it, then you are a provider. In particular, I think it's interesting because foundation models are being enhanced with the capability to call out to external systems. So I wonder if the external systems themselves would fall under the remit of this act and would have to fulfill some part of this legislation. I'm not sure. I'd suggest, if you're interested in that, I suggest you check the text. What else is there? Yeah, no, okay, that's okay. All right, next. Also, a quick drink. I'm just recovering from COVID, so I'm still coughing a lot. So apologies if I go into a coughing fit in the middle of this. So right at the start of the Act clarifies the scope of the definition. So we've talked a little bit about some definitions of a provider, but specifically, what does this apply to? The most interesting element in this section is that it includes any AI tool consumed within the EU. So it doesn't matter if you're based in the US, these laws will still apply to you if you have customers or users that are based in the EU. It also includes any general purpose AI. So that includes things like large language models, diffusion models, generative AI models, anything Gen AI. And this inclusion overrides any subsequent discussions about the applications of the AI later on. So yeah, already we've got a very definitive statement from the EU that saying that basically any generative AI model automatically falls under the scope of this and must be treated as a high risk application. I'll talk more about that in a second. The legislation excludes military or national security applications, and a recent addition also excludes research and development projects and non-professional projects. So these weren't excluded from the original scope of the legislation, and rightly so, the open source community threw their hands up in the air saying, how can we abide by this? But of course, if you are a business that leverages an open source project and then uses that AI system with users in the EU, then you will become the provider and you will be liable. I also think it's quite interesting that this seems to exclude any application that is internal to your business. You could probably justify as an internal application being for research and development purposes, potentially, but I'm not sure. You'd have to double check the text. So let's talk about the underlying structure of the legislation. The Act is based upon an underlying appraisal of the risk for specific applications, for specific use cases. There are 4 levels of risk: no risk, low risk, high risk, and prohibited. The first and lowest level is minimal risk or no risk. It's intended to represent the situation where it would be very unlikely to cause any harm to people. This level comprises of all of the applications of AI that are not explicitly specified in the subsequent sections. Next, we have the limited level of risk. This includes most generative AI, as they all have a basic requirement to effectively explain that the individual is communicating with a system and not a real person. However, forward-looking businesses might want to investigate how they can improve their transparency obligations beyond what is expected now. So, for example, you could take a leaf out of the UK Financial Services Playbook and begin to explain to the user why decisions have been made and what they can do if they'd like to contest it. In the third level, you'll find the high-risk set of applications. I'll detail what this category includes shortly. Much of the legislation, nearly all, probably 95% of the legislative act is spent introducing procedures for these high-risk applications. And finally, the last element in the risk-based approach represents the prohibited AI applications. These are deemed to be unacceptable in the terms of the likelihood of harm. And again, I'll list those shortly. Before we do, let's find out what happens if you break any of these rules. The legislation has outlined fiscal penalties for any company that does not comply. The legislation says that they should be proportionate and dissuasive. So you can imagine that the largest companies in the world are going to get fined more than the smallest. The highest penalty goes to those who use AI in applications that are designed that are being designated as prohibited. Fines can extend up to a maximum of 6% of global revenue, or 30 million euros, whichever is higher. For a high-risk violation, fines can go as high as 4% or 20 million. And finally, if a business is found to be misleading the relevant authorities, they can receive a fine of up to 2% of global revenue or 10 million euros, whichever is higher. So the fines are significant and they are in line with other EU legislation such as GDPR. It's interesting to know that there are no criminal penalties for violation, however. So, for example, you could have, you might have thought that the legislators might have had the conversation about what happens if harm does come to people based upon some of these decisions. Is there a negligence element there? But it's not being included in the Act, unlike something like the UK's Online Safety Bill, which does have criminal penalties as well as fiscal, for example. All right. So moving on to the section that everyone is really interested in. What applications are prohibited? There's been a few interesting developments about the prohibited section. It's got more complicated over time. It started off being quite simple. Apparently, the French, in particular, the French delegation, required exceptions for national security use. So there's a lot. There's a lot more talking about national security and military use in the Acts now, where there wasn't so much before. Um, and the way that the legislation handles it is that they've split it up into three distinct groups of entities that these laws apply to. So the first group is everyone, every single user, you, me, everybody in the EU. Everybody. If I was in the EU, then it would apply to me too. The legislation prohibits the use of AI to distort the behavior of EU citizens to the point where it causes harm. Okay, so basically, you know, don't do harm. The second group includes specific demographic groups. They talk about users that are less able to, basically more vulnerable to the effects of AI. And the legislation prohibits AI systems that take advantage of the vulnerabilities of these specific groups. And finally, there's a third group that prevents specific AI applications for law enforcement, in particular. And actually, this is a bit confusing. This because there are sections later in the document that kind of conflict a little bit, but we'll get to those in a moment. In particular, it will be illegal for law enforcement agencies to use biometric identification techniques. So this is an interesting proposition that has its opponents. You know, like I mentioned, the French are opposed to this. So we don't know if this is going to make it into the final draft. Let's see. So talking about high-risk applications now. So this is possibly where you may find yourself when you're working in your business. There are quite a range of included applications here that are fairly common. So yeah, let's talk about it. So the bulk of the legislation introduces procedures to deal with high-risk applications. The whole intent is to basically, you are allowed to still deploy a high-risk AI system, but you have to basically de-risk it to the point where or demonstrate that you have de-risked it to a point where harm is unlikely. So an application is classed as high risk if, firstly, again, this is a little bit of a list again. So firstly, it's deemed as high risk if there's another piece of legislation that deems it as high risk. So they're opening the door to other bits of future legislation. It's also high risk if it's part of a safety critical system, or it's also high risk if the application uses or is used in the following domains. And I'll slow down here because this list is quite long. This is basically the list of potential areas where it could be used or specific applications. So biometrics, critical infrastructure, so things like roads, rail, travel, airports, things like that. Education, employment, essential services like water, electric, internet, law enforcement, borders and migration, justice. And I'll pause there for a second because there were a few new high-risk categories that were added in the latest draft, which are potentially controversial. The new ones are credit scoring and any use in life or health insurance. There's also a stipulation in there that announces that these high-risk applications may change over time. So just because it's not there now doesn't mean it's going to be there in the future. Aside from the list of applications, the legislation also includes several tidbits that are quite easy to miss. And I've included some of them because they're quite interesting and sometimes quite hard to interpret. So, first one that I noticed was distributors shall verify conformity markings and declarations. This is saying that anybody that distributes high-risk AI applications will have to verify that the AI system conforms. So this means that if you have a service that is offering a hub of any kind, if you're potentially offering AI for specific applications, and those applications fall into any of these high risk categories, then you will have a burden to double check that they have conformity. And I mean, they're not clear on what happens if they don't. I guess they want you to remove those applications. They've also mentioned that providers can develop applications in regulatory sandboxes and test in real world conditions. But there isn't a very clear definition of what a sandbox is. I don't know if it's like a legal thing or if it's like a technical thing. They've basically left a placeholder in there to say that the underlying, excuse me, the underlying regulators in each country will help define these sandboxes. And then SMEs will get a priority access to these sandboxes, and the fees are commensurate to size. So they're implying that you have to pay to get access to any of these sandboxes, which is interesting. Commission will also set up and maintain a EU-wide database of high-risk AI systems. That will be very interesting to look at if it's made public. I assume they're going to make it public, but there's no wording in there to say that. And serious incidents shall be made no later than 15 days after the providers became aware. There's no definition of what a serious incident is. So I don't know if they mean something that someone has come to harm and the company has become aware of it, if that's a serious incident, or if it's just acknowledgement that the model is now not performing as well as it should do. Is that a serious incident? I'm not sure. That's also not very clear. Right, so those little that placed to one side for a moment. Let's talk about what you need to do if you are if you fall under the banner of running a high risk application. So yeah, basically you must follow a set of procedures to ensure that you've de-risked your application as much as possible. All of these high risk requirements are eventually evaluated by a compliance review, but the actual specifics surrounding a review is yet to be determined. There's no clear information about what a compliance review looks like. There are some specifications as to what proof is required in a compliance review, but yeah, it's not clear how it's going to be performed or by whom. So I've taken all of those requirements and tried to condense them down and categorize them into more engineering-friendly language. So I've called the first set of requirements risk management, because this includes procedures that attempt to identify and control risks. They specify that you should perform tests to assure effectiveness, and they introduce special requirements for any high-risk AI application that is going to be used by under 18s. So this is the one piece of the legislation that specifies an age policy. So it's unclear how you may decide to restrict the use of your model to people over the age of 18, so you don't have to fulfill this part of the legislation. The second requirement falls under data governance. Here, there are recommendations that you should have good quality data and specific processes to ensure that the data is fit for purpose. So, typical data science type stuff. I call the third category quality management. This is a bit vague, but it includes a wide range of documentation, including the design documentation, the product definition, operational documentation, and risk documentation. And finally, all of those are grouped and bundled together as a proof of conformity. Excuse me. They also state that these documents should be kept for at least 10 years after publication. So this is the first example of retaining data for a certain length of time. The fourth category is MLOps. So the legislation states that AI systems must be overseen by real people. They call them natural persons, not another AI system. And there should be systems in place to ensure that the application is robust, monitored, and logged. So interestingly, they actually include specific technical language requiring the use of logging and state that all logs and metrics should be stored for at least 6 months. So yeah, potentially 6 months worth of monitoring data could be quite big. So you might need to take a look at your MLOps monitoring and logging systems. And finally, I've got a section called MLSecOps. The legislation states that the AI application must be secure. They've also included, again, some technical language like feedback loops, data poisoning, and adversarial attacks. And again, it's interesting that they've included specific technical language here, but I would any potential attack vector and any potential cause of instability. All right, so we're moving through the pyramid now, and we're down to low risk applications. So this is the third category. There used to be, in the previous legislation, there used to be a previous definition of how developers should classify low risk applications. Not developers, but people, how we should classify low risk applications. But there was quite a lot of pushback about not being specific about the applications. So they've removed that language and replaced it with now certain AI systems fall under the low risk category. The list includes, and this is the first sort of strange, controversial one, biometric categorization systems. So know that the word biometric was included in the high risk and the prohibited section. So there's quite a lot of there's a cross-cutting kind of concerns here. So be very careful if you are in the kind of demographic space. Next, we've got emotion recognition systems. Anything that generates or manipulates image, audio, or video content that appreciably resembles existing persons, objects, places, other entities, or events. So basically, they're talking about Gen AI there. If you fall under that list, then you have one very simple requirement. The requirement is that the user is informed that they are interacting with an AI system. I'd suggest that all businesses using AI or presenting AI to users, at least, should be transparent from the beginning. It's quite likely that this list of low-risk applications is is going to increase. And it's also quite likely that the requirements will also increase as well. So it's best to be ahead of the curve and transparent as you can now. Okay, so final thoughts. So what I've tried to do here is condense the legislation, because it's a huge thing. It's hundreds of pages into a handful of slides. And obviously that brings challenges, because there's probably details that might be important to you that I've missed. But I hope that I've achieved that in general, I've given you a sense of what's in the legislation here. But of course, remember that this is just my interpretation. If you have any questions about the legislation, then I recommend that you either take a look at the legislation yourself, or have a lawyer do it for you, or get in touch with Winda.ai and we can help you through some of the more technical aspects of it. We can't provide any legal advice, but we can help you implement the technical recommendations. Also, you might have noticed that each of the slides included sort of slightly darker citations to the specific article in the legislation where you can find the wording. So if there's one little bit that you're interested in, then you can just check out that particular article in the legislation. And I've also included links to the legislation and other interesting documents at the end of this presentation. I'll publish this presentation as a blog post a few days after today. You'll include the links there, and I'll also just present them at the end. So yeah, in summary, the EU AI Act is a groundbreaking piece of legislation that places wide-ranging burdens on the developers of AI systems. But the burdens are not insurmountable. In general, they make sense. Don't do harm, don't cause people harm, and make sure your systems are robust. It's the type of things that engineers have been talking about for a long time. So it's likely that you're doing something like this already in your organization. And it's also important to remember that this legislation is at least 2 years away from becoming a legal requirement, so you have time. In 2 weeks' time, I'm presenting another webinar, which is an interview with someone that was actually involved in the legislative process, Javier Campos. I've included a QR code there at the top right, which will take you to the Window.ai events page where you can register and watch that webinar. I've also got a link at the bottom there to the Window AI blog, which includes lots more information. And if you look at the bottom of every page on the Window.ai website, including the blog, you'll find a newsletter sign-up form where you can sign up and receive more exciting stuff when we produce it. So yeah, if you found this presentation interesting, then I definitely recommend that you join me for the interview in 2 weeks' time. And if you've got any more questions after this, then check out our website or email me at phil.window.ai, phil@window.ai. And for now, I will put the links up on the next slide and begin to start asking any questions if there are any. So just give me a few minutes to find those. Okay, quick question. Yeah, first one, will it be recorded? Yeah, it will be recorded. I'll publish it on my blog in a few days' time. If we have your contact details, then we will share that with you. If we don't, you'll just have to come back and sign up for the newsletter. A couple of thank yous. Thank you very much for all of those kind words. Thanks. That's really nice. Okay, would you mind clarifying the under 18 section, please? Does it mean that applications that cater on this are automatically high risk? No, that wasn't the case. It was if it fell into the high risk category, and I think it was. I'll have to double check the actual article. Just give me a second to scroll back. Yeah, so it was just in the high risk section. So if your application falls under the list of high risk applications and is required, if it falls under that, then there were extra risk management controls that you would have to do if you had users that were under 18. So it doesn't apply to everything, as far as I can tell. It only applies if your application falls under being high risk. Okay, hopefully that makes sense. And another one. Does it specify what it means by harm to a person? Yeah, good question. No, it doesn't. And there's also no definitions of what harm to property means either. So I don't know, there's no sort of financial, cause more damage than X amount of money. So yeah, the only sort of definition there is they are talking about like specific individuals, natural persons is the term that they use. So real people. It doesn't mention anything about groups or anything like that. But that's a very good question, actually. It's not something I picked up on. But yeah, we would have to check the text to see if there was any further definition on that. As far as I can tell, yeah, no clear definition. Okay, so that's the end of the questions so far. I'll just leave this slide up for a few more minutes and come back if there's any more questions. But for now, I hope you have a good night. Definitely check out window.ai and get in touch if you need any help with any of the technical aspects and sign up for our newsletter. Thanks a lot. Bye-bye.